much later.
We're just going to wait a few more minutes for participants to roll in. We're just going to wait one more minute and we'll go ahead and get started soon. All right, let's go ahead and get started. Good afternoon, everybody. Welcome to this wonderful panel on returning to production, issues that we're going to face in light of COVID-19. This is co-sponsored by the LA County Bar's Entertainment Law and IP section, known as ELIPS, and the Association of Media and Entertainment Council's Women Who Lead Board. My name is Talene Galusian. I'm counsel at SAG-AFTRA. I'm on the committee for ELIPS and also a member of the Women Who Lead Board. We're all very excited to be here on behalf of both organizations. I can say that we welcome everybody and thank you for joining. Before we go ahead and jump right in, I wanted to go over some housekeeping rules so we can all make sure we get that CLE credit that we want. So you'll be receiving an email in about 7 to 10 business days with your CLE credit, so make sure to look out for that. And as far as formatting goes, we do have a Q&A reserved for the end of the panel. So once our panelists are done with their presentations, we'll open it up for Q&A. Because this is Zoom, I'm going to encourage everybody to use the Q&A function at the bottom of your screen. So if you just look towards the bottom, you'll see a Q&A. You'll also see a chat. You want to use the Q&A, and what we'll do is filter the questions out to the appropriate panelist to make sure that we can get them answered for you. All right, Fatima, is there anything else you think I might have missed before we go ahead and jump right in? No, I don't think so. All right, let's go ahead and get started. So I'd love to introduce Duncan Crabtree-reland, COO and General Counsel of SAG-AFTRA, to kick it off for us. So Duncan, if you can start with just a little bit about yourself and let us know what you think about the issues that we're going to face for COVID-19 and production.
Sure, thanks, Talene. Really appreciate it. Really excited to be part of this panel with such distinguished co-panelists, Anthony, Katherine, Liz. So very excited about that. As you said, I'm the CEO and General Counsel at SAG-AFTRA. So I'm celebrating my 20th year here with a pandemic and trying to figure out how we can contribute to getting the industry restarted. So I think I get the privilege of talking a little bit about the process that resulted in some of the documents that are out there so far. But before I did that, I want to just begin by saying that it's super important to our members and to SAG-AFTRA to get production resumed. Our preliminary estimates are that our members have lost about $500 million in income collectively since the pandemic shutdowns began. And obviously that is a devastating impact on our members. And we're talking not just about famous stars, but also we're talking about just working actors, stunt performers, background performers, people all across, our singers, our dancers, all across the areas that we represent. So we're very, very concerned about it and working really hard to help reopen the industry. But of course, it's crucial that any kind of reopening be done in a manner that provides an adequate level of safety for the workers who are coming back to work. That's both just as a humane issue and also in order to help protect the industry itself. So I think that's been something that everyone's understood and sort of agreed to from the beginning. The first steps that were really taken to try to figure out how this was going to work, how the reopening of the industry was going to play out, were undertaken by a joint working group of management and labor that was facilitated through the Contract Services Task Force, which for those who aren't familiar is a pre-existing standing industry group, industry management labor group that works on safety issues and has been doing so, issues safety bulletins and addresses the various types of onset safety concerns and production safety concerns that have arisen. So that forum was used as a way to start the conversation between management and labor, in particular because we all recognized that something needed to be done quickly because governments were starting to think about this issue and wanting to put out guidelines and rules. And because our industry is so unique and works in such unique ways, it was really clear that those government agencies needed some guidance from the people who are actually involved in making the industry work. So the result of that was what's being called the white paper. It's a document that's in the packet of materials for this program. It's also been widely distributed online. And it is a very beautifully produced document. If you look at it, lots of photos. It's perfect for handing out to all different types of government agencies and government officials to entice them into reading. It's 22 pages of detailed material about how the perspective that is brought to how the industry should reopen. I do want to emphasize it's really not meant to be the detailed protocols about how the industry functionally reopens. It's meant to set some high-level parameters on the type of concerns that everyone shared. And I think there's a few key points that you can pull out of those 22 pages that really jump out as part of what really is essential to a safer return to work. And at least at SAG-AFTRA, we're trying to call it a safer return to work because we acknowledge and we feel that everyone should understand that this is not about creating a 100% guaranteed safe workplace, that's probably impossible until such time, perhaps, as we have a vaccine, or maybe it's not ever going to be possible. But what we're talking about is mitigating risk and making sure that the level of risk and the protective measures that are taken are appropriate, and that the workers who are placed in those risk situations are fully informed and understand what they are being exposed to. So, so in this white paper document, you'll find such key provisions as an agreement amongst management and labor that testing is an essential element of a safe return to work. We'll talk more about that in a minute. You'll also find an agreement that there needs to be an individual or individuals who are designated as responsible for ensuring COVID-related safety on set and throughout production. In the white paper, that's called a COVID compliance officer, and there are duties that are associated with that particular type of position, but essentially the core elements of it are having some person who's not a low-level person, someone who's in a position of authority, who is responsible for making sure that COVID safety protocols are taken seriously on set, that they're complied with, and that there's a place for people to go in the event that they observe something that's wrong happening or have concerns about COVID on set. Of course, there are a lot of additional provisions regarding things such as the use of PPE, personal protective equipment. I imagine that'll come up in a number of our conversations today. Also, the importance of physical distancing wherever it's possible, and a number of detailed protocols regarding sanitation and safety, food safety, and sort of changes in the way that we expect sets to operate in order to provide a more safe and secure environment from COVID. The second major document that's come out is what I'll call the unions document. This was just released last Friday, and it's also widely available publicly online. And this is a joint document that was issued by the Directors Guild, SAG-AFTRA, the IATSE, and the Teamsters. And this is a document that we worked together to create, which contains a much more detailed set of protocols for how production might operate, and in particular addresses the question of testing, which I know is at the forefront of everyone's minds. The document, I think, lays out a really clear case for why testing is so important and why it's particularly important to people like actors who will have to work in many cases without PPE and without physical distancing, and lays out the frequency of testing, and I think is kind of unique in that it also lays out all the science behind it. There's a part two is a kind of very technical sciencey piece which really explains from the epidemiologists that were retained by the unions why testing is so important and why the frequency of testing we're talking about is crucial. It also talks about the idea of sets being divided up into zones based on the exposure of the individuals who are working on those sets. Zone A being the core part of the set where in particular actors, but possibly others sometimes, but mostly actors have to work without PPE and without physical distancing, and ensuring that the number of people who come in proximity to those actors is as few as possible, and that those people are tested perhaps more rigorously to help make sure that there's a minimum risk of transmitting COVID, even though there's an absence of PPE and there's this lack of physical distancing. Then there's a zone B, which is perhaps could be a concentric circle around that, or at least is outside of zone A. And zone B is where crew typically would be working who don't need to have close contact with performers or have contact with performers without PPE and without physical distancing. And in that zone, people might be tested less frequently and the restrictions might be a little bit different. And then there's the zone C, which is the outside world. I think measures such as the zone system, such as testing, such as having the COVID supervisor, and other measures specific to, for example, hair, makeup, wardrobe, and props, those are all going to be very essential to having a comfort level for performers to return to work on sets. And so I think those are some of the key provisions. Just in terms of the process, I would mention that I think it really speaks volumes that you have unions like SAG-AFTRA, DGA, IA, and Teamsters doing this work jointly, releasing joint documents. That's not something that you see very often. Obviously, the people we represent do different jobs. They all have different perspectives on things, but as far as safety goes, there's really a unified approach to it. And it's not really going to be possible to parse out different people on sets in terms of some of these safety protocols, things like testing, things like PPE use and distancing. This has got to be done collectively, because if it's not done collectively, it won't have the desired results. It won't prove effective, and it won't be a safer set. So I think that there's a real significance that should be taken from the fact that all of these unions across different parts of the workforce and different aspects of production have all come together to speak with one voice and state that these types of protocols are what need to be in place in order to ensure that the workers we represent are adequately safe on set for production to resume. The last little note I'll make before I sign off is a lot of people reading these documents have said to me, these look like they're designed for the major studios, for large scale production. What about smaller productions? What about independent feature films, for example? What about low budget projects? What about television commercials, et cetera? And the answer is the principles in these documents from our perspective are universally applicable. Obviously, the implementation may be different in different types of work environments. And so discussions are ongoing with producers, for example, in those different areas to make sure that the protocols work for that type of production while still providing the level of safety that all workers and our performers deserve. So I think I'll stop there, but thanks very much, Talene, and pass it along to whomever's coming next.
Thank you, Duncan. We're going to hear next from Anthony Amendola, who's partner at MSK, Mitchell Silverberg. Anthony, take it away.
Well, good afternoon, everybody. It's a pleasure to be here in this virtual world. I wanted to reiterate something that Duncan said, which was that the white paper is an amazing achievement, because we really saw the entire industry, all of the guilds and the producers really coming together. They had very detailed meetings about the various aspects of production, and really worked together to come up with a roadmap or a blueprint for how to resume production. And I guess it was a pretty persuasive document, because as you may know, the state of California, for example, did not issue its own protocols, but has simply adopted the white paper, so to speak, as the protocols for resuming production in the state. Before I get into any details, I give you a little bit of background about myself. I've had the pleasure of representing producers in the industry for more than 30 years. As a partner at MSK, I also spent a period of my career as an in-house labor and employment lawyer at Warner Brothers. Most of my clients are producers, everything from the AMPTP and large studios and producers, and as well as many small independent producers. So I thought what I would do is spend my time just sort of highlighting, based on the experiences that I've had with clients over the past few months, with sort of identifying what I think is sort of the top 10 things that producers and their counsel need to consider as they work out their return to work protocols and plans and resume production. And you'll see that there's really a huge patchwork of regulations and protocols that may apply to any production. So I think the first thing that everyone needs to think about is, what are the applicable laws, ordinances, and orders that apply to, to filming and resuming employment and work in a particular jurisdiction. What we've seen is that most states, certainly some more than others, have orders that prohibited, for the most part, people gathering, and there are still significant limitations in many jurisdictions with respect to how many people can be, in a location. And there are very detailed, COVID orders that have been, published, both with respect to federal, state, local, and we see here in LA County, for example, city governments. The city of Los Angeles, cities like Pasadena, Glendale, Burbank, all have their own opinions and recommendations that their county health departments, city health departments have issued. So a producer really needs to make sure that they've done their homework at every level of government, and certainly if you're going to be filming in other locations, in other cities, states, or countries, the laws vary considerably throughout the world. The next thing that producers need to think about is, what are the specific government protocols that are going to apply to production? As I mentioned, at least sitting here in California, the state did not issue its own protocols, but it has adopted the white paper. And what's interesting about this is that while the white paper was agreed to between the unions and the producers who are members of the AMPTP, the state's adoption of it applies across the board to all productions in the state of California. So even non-union productions need to follow the protocols that are set forth in the white paper. So that's sort of the second thing that everyone needs to be considering. And you'll see that the county, for example, of Los Angeles has also referenced the state adoption of the protocols and then has really issued more detailed, specific protocols that must be followed in LA County. And those can be obtained from the LA County's website. There's something called Appendix J, which the county issued, which is really the reopening protocols for the production environment. But the county also notes that in the course of production, employers are going to be conducting business in other places that are regulated. So they specifically incorporate and reference the protocols that are particular to restaurants and bars, to retail operations, to office spaces, for example, for your production offices, to warehouse and manufacturing and construction. So there may be specific aspects of a production that will be governed not only by Appendix J, but also by some of the other appendices that the county has published on their website. And it's broken down by industry. So, and you'll see there's a lot of overlap, but they were tailored for specific types of work. Then, of course, the number 3 issue that needs to be considered is, what are the union rules and requirements that are going to be applicable? As Duncan mentioned, the white paper was the starting point. Some of the unions have then issued the additional document that's been distributed, the safer path to production. And employers are going to have to make sure that, if it's a union production, that they know, what is in the collective bargaining agreements. There are going to be probably some amendments or side letters that are going to be negotiated on an industry-wide basis with some of the guilds to implement certain aspects of the white paper. But in addition to that, if it is not subject to an industry-wide agreement and the producer has just its own agreement with any of the guilds, anything to do with safety and health is an issue that needs to be bargained with a union. And so that's something that the producer needs to be aware of and make sure that it's not unilaterally imposing conditions that haven't been discussed with the applicable unions. The number 4 thing that I think people need to be aware of is that there are also specific occupational safety and health administration requirements at both the federal and state levels, OSHA requirements. And whoever is involved in really setting up the return to work protocols needs to be familiar with what OSHA requires. I'll note, for example, that Cal OSHA has issued a statement that at a minimum, all California employers must follow all CDC guidelines. Now, as you may know, the CDC guidelines and recommendations are not mandated as laws or orders, they are recommendations. But as I read the Cal OSHA statement, Cal OSHA is saying that the CDC guidelines must be followed. Now, fortunately, the CDC guidelines are actually less prescriptive than what has already been announced in the white paper and what the unions and the producers are discussing. So, it's going to be a fairly, easy level that can be followed. I'm sorry, I'm having video problems. In any event, hopefully you can hear me. The number 5 issue that I'd like you all to think about is that there are significant obligations under the various disability laws that prohibit discrimination against people who have disabilities. And for example, the Americans with Disabilities Act, the California Fair Employment Housing Act, and these laws very broadly define what is a disability, and virtually any of the anyone who has COVID or an underlying condition that could make someone susceptible to COVID may be a disability under these laws. And under the disability laws, if someone is unable to work or has restrictions based on disability, the employer has a duty to engage in the interactive process to determine whether or not the disability can be accommodated, and they can only deny someone's medical accommodation if it would impose an undue hardship on the employer. Now, if someone has a temporary inability to work, that may make them unable to work on a production because typically these are short-term assignments, but the producer needs to be aware that it has to look at those obligations under the ADA. The ADA also has, which I guess would be my number 6 requirement, some very specific obligations with respect to things like medical inquiries, screening, testing. These are all going to be a necessary component to any COVID return to work program. But for example, the Americans with Disabilities Act and the state law are very clear that an employer may not make medical inquiries prior to making a job offer. You can't ask applicants about their medical circumstances. You can't require applicants to take a COVID test or to answer a screening questionnaire. So, the employer has to make sure that if it's going to implement screening, testing, and any other kind of medical inquiry, all of which I think are imperative in the current circumstances, they must make sure that they're doing so in compliance with these legal requirements to not test or make inquiries pre-employment. And also the ADA and many state laws also address privacy concerns. If the employer is going to gather information about someone's medical circumstances, they have to ensure that that information is only accessible to a very small group of people and that it is properly and separately maintained from employment files because it is highly personal information. Number 7, moving kind of quickly, is that employers need to think about wage and hour issues. There are very complex wage and hour laws that apply, obviously, to all workplaces, and many of the things that employers and producers are talking about in the age of COVID are going to open up potential issues with respect to wage and hour law. For example, if when an employee is under the control of an employer, it may well be that the employee, at least we're talking about non-exempt hourly employees, being under the control of the employer may mean that that time is hours worked. So when employers are thinking about mandatory quarantines, for example, having everyone on a production stay in a certain hotel and then traveling the employees to the set and bringing them back so that they minimize their likelihood of being exposed to COVID, which may make some business sense, the employer has to realize that they're going to, if it's a union production, they're going to have to negotiate with unions with respect to how to compensate people for these hours. And if it's non-union, they need to confirm whether or not state or local law would require, or federal law would require the employees to be paid potentially for 24 hours. Under federal law, there's an exception that allows an employer and employee who are basically entering into a 24-hour-a-day work relationship to exclude 8 hours per day for sleeping if that 8 hours is made available. But some states, for example, California, don't recognize that exemption. My number 8 point is you are hearing a lot about waivers, and a lot of people are saying, oh, get people to sign waivers. I want everyone to understand that at least in California, and certainly with respect to employees, it may not be lawful to ask people to sign a waiver as a condition of employment. There are significant public policy concerns, workers' compensation, and other statutes that really prohibit an employer from saying, in order to work for us, you need to waive your rights to a safe workplace. So as a general matter, employees should not be asked to sign, waivers. They certainly can be informed of the protocols, be required to follow the protocols, but the employer is obligated to provide a safe workplace And if someone is injured, in most circumstances, workers' compensation is going to provide, the remedy to the employee who has been injured. But requiring a waiver is certainly something that I think should not be routinely considered for employees. It may be appropriate with third parties, with independent contractors, et cetera, but with respect to the employment relationship, that is not something that should be required. My ninth point is that employers really also need to be educated on any COVID-specific laws that may apply with respect to, for example, benefits. There's a law that Congress passed as part of the CARE Act, which is called the Family First Act, that obligates employers that have fewer than 500 employees to provide sick leave and certain family leave under certain circumstances. The laws are very detailed. There's lots of materials out there on what these laws require, but employers, including producers, need to understand that these laws may apply. And then there are additionally the potential of state or local sick pay laws or leave laws that may apply. The city of Los Angeles has its own ordinance that applies to employers with more than 500 employees that also provides sort of a comparable sick pay and family leave benefit that is consistent with what the federal law requires. And then the last thing I want to say is that producers and all employers need to have a strong anti-retaliation policy. In the age of COVID in particular, but really in all workplaces, employees are encouraged to raise concerns about work conditions and safety and health issues. And if employees are going to be encouraged, as they should, to raise concerns, to disclose potential hazards, they need to have the understanding and guarantee that they're not going to be retaliated against for doing so. And if an employer retaliates, that may well violate numerous laws and provisions of collective bargaining agreements. So it's a lot to think about, a lot of homework that needs to be done for counsel that's representing producers, and make sure that you've really dotted your I's and crossed your T's before people resume production really anywhere in the world, but certainly here in California. Thank you.
Thank you, Anthony. Thank you. We're going to hear next from Katherine Hren. Katherine is partner at Ballard Rosenberg. Katherine?
Hi, good afternoon, everybody. Thank you for having me today and for joining us. So my perspective is slightly different. My practice is exclusively labor and employment law, representing all different industries, including production. So I've had the privilege of working with employers over the past several weeks and months as they've closed down businesses. I've been working with companies and organizations that stayed in business and helped navigate through as the days change day by day and the needs change. And over the last several weeks, working with employers in reopening businesses and what that looks like. So I've had the unique privilege of seeing what those concerns are and being confronted with some of them and helping employers navigate through it. So by now, after listening to Duncan and to Anthony, I'm sure you're feeling even more confused than ever, and you're not alone, because there is a dizzying array of legislation and regulations out there for employers to have to figure it out, essentially. The government has told employers, it's on you, you figure it out, and you make it work. So one document that I particularly like, and for those I've seen a lot of questions in the chat box, there are materials that are attached to our presentation. One of the last documents is a document that Anthony mentioned that is called Appendix J. And it is an attachment or appendix to the LA County Safer at Home Ordinance. Whether you are doing work in the County of LA or not, I would implore you to look at that document as a great roadmap. It's about a 10-page document, so it's not as cumbersome as some of the other documents that you have to take a look at. And it basically is listed like a checkbox. If you are in the County of LA and are employed in this industry, or working in this industry, you are required to go through that document. Big employer, small employer, union, non-union, every single employer in the County of LA is required to go through that document and check the box for every single provision that may apply. So that's a great roadmap to get started, because it helps you navigate through the screening process, social distancing measures, and all of the kind of basics to reopening. I had a client call me a couple of weeks ago and said, we've all been kind of working from home, and some people were laid off and let go, and we're ready to reopen on Monday. Anything I need to know? And now you're in that opportunity where you have the chance to take the time now to get your organization ready. You need to be thinking about little things and big things. For instance, one big thing, and Duncan really pressed on it, was testing and screening. So you have to make a determination. Are you going to be requiring COVID testing of employees or people on site? You are permitted to condition return to work on someone having a negative test result for COVID-19. So it's something that you wanted to do, you could do so. I am recommending to all my clients, and so is CDC and LA County, that you do some sort of screening. If you're looking at that County of LA Appendix J document, it does require that the employer do screening, meaning you could do a screening at home, a self-screening at home, or you could do screening on site. So you need to consider what type of screening you'll do. Think about, if anybody on this call has been to a doctor in the last month or two, you know you either show up there and you have to sign a form that says you don't have symptoms, or maybe you're getting it electronically and you can fill it out on your phone and hit the checkbox as to whether you've had any of those symptoms. You should consider utilizing that going forward. A really easy thing to do would be to have a program that's on everybody's mobile device. They hit a few buttons as they self-screen in the morning before they come onto site, onto location, and indicate whether or not they have any of the symptoms or characteristics listed. That's a great way to help ensure the workplace stays safe and helps ensure that sick people stay home. So you should be developing those type of protocols before even thinking of bringing people back and making decisions as to how you're going to do that at home, on location. Are you going to be temperature taking on site? The CDC is recommending it. You know, all these documents that you've been looking at in the attachments, the Appendix J, all recommend temperature taking on site if possible. So you need to determine who is going to be doing that, training that individual on doing it. I had a client call me a few weeks ago, and they had about 2 or 3 people tested positive in a couple weeks span in a manufacturing type of setting. And I asked, are you doing screening? He said, yeah, we're doing temperature takings. And I said, what have the readings been? Had anybody tested high? And he said, I don't know, I'm gonna go ask the manager who's been doing it. And when he went and asked the manager who was doing it, the manager said, no, all of the numbers have been between 93 and 97. So it gave us a little bit of an indicator that that thermometer was probably broken, and the person who was taking the temperature wasn't properly trained on it. So these are simple things that you need to be thinking about. Everybody who's going to be, any employee who's coming back on location has to be trained in the new protocols. And in order to determine what those new protocols are, you have to develop your safety plan and your safety protocols. So as you're going through the white sheet or you're going through Appendix J, you have to understand what it is that you're going to be doing differently so that you can then educate your employees prior to coming back on location. A lot of employers are doing Zoom trainings prior, or they're bringing people on site and actually going through with them and training them on how they're going to navigate through their particular position. You all on this call are in a very unique situation because it's not limited to one group of employees. You have your cast and crew, you've got office personnel, you've got sanitation, you've got janitorial, you have food service. So you really have so many different avenues that you need to think about, and each, lack of better words, department or classification of employees is going to need their unique and own training. So you need to be working now with your production managers and other safety personnel to develop what is the training protocol for each of these classifications and how are we going to be delivering it to employees. You need to be thinking about what you might be doing differently on set, on location, wherever you may be, including the social distancing and how we can communicate that to individuals. I also want to talk briefly about the idea of return to work. And I want to touch on a couple of things that both Duncan and Anthony mentioned. So what you have to be prepared for is when we start to, lack of better words, reopen those doors and ask people to come back to work, you're going to have several different baskets of people. You're going to have one basket that's going to say, no problem, I'm eager, I'm going to show up and I'll be right there. You're going to have a second basket, and Anthony touched on that are people with disabilities, chronic conditions, autoimmune compromised individuals who may be very reluctant to come back to work because of COVID-19, or may not feel that you as an employer are doing enough to ensure or make a better or safer work environment. So the first thing with that and building confidence is, one, building that safety protocol and properly communicating it to your employees so that they have a better sense of what you're doing so that they can have an understanding of whether that fear is realistic for them or not. As an employer, as Anthony mentioned, you are governed by both the Federal Americans with Disabilities Act and a similar California law, which says that you as an employer have an obligation to provide a reasonable accommodation to an employee with a disability. And a reasonable accommodation could mean in this instance that we allow the person to work from home if it's a work from home position, or that you permit the employee to be on a leave of absence until it is safer for that individual to return to work. So that's another basket of people that you have to be considerate about, and you have to really look at a case-by-case basis to whether or not there is an accommodation available. The third category of people are going to be individuals who are not themselves disabled, but that have people with disabilities at home with them, or people with compromised immune systems that they are coming back home to. So again, those are going to need to be individualized conversations that we have with our employees to determine whether or not there's a concern. Another piece I want to mention is the safety complaint. As both Duncan and Anthony mentioned, there is a huge concern out there about employee safety. And it's so refreshing to hear that employees and employers are working together on these issues, because that's the only way that we're going to get through all of this. But one thing I'm reminding my clients and employers is that if an employee raises a safety issue, whether they raise that separately, saying that they don't feel the workplace is safe for them and others because of fill in the blank, or you get a complaint by more than one employee, that is what you all know as a protected concerted activity. So we can't take any retaliatory measures against an employee for saying, I can't come back to work because you haven't provided a safe environment, or once on the work site, they raise workplace concerns about the safety of the workplace. So be mindful when you hear those concerns, when those claims are raised, because as an employer, you don't want to be stepping in it and getting a retaliation type of claim. Also want to touch on this idea of return to work and once individuals are back to work. As Anthony mentioned, there is part of the CARES Act was something called the Families First Coronavirus Response Act. And if you are an employer that is under 500, you'll be covered by that. If you are in the city of LA and you have more than 500, you'll be covered under the city's counterpart. So you're pretty much covered anyway. One of the provisions that hasn't gotten a lot of attention that I just want to highlight, and we could spend over an hour just talking about the Families First Act, but there's a provision in there that says if an individual is unable to work because he or she must stay home to care for a child because that child's school is closed, that employee is eligible for up to 12 weeks of time off. And you as the employer would be required to pay that employee for 12 weeks at 2/3 of that employee's rate of pay. And it's capped each day at $210, I believe. What's the important piece I want to mention about that is it also applies if the employee is returning to work. So if you are an employer and you're extending an offer of employment for somebody to return to work, and they were employed by that employer for 30 of the 60 days prior to the layoff happening back in March, that employee would be eligible for the leave. So if you have someone telling you they can't come back to work because school is still closed and they have no childcare for their children, they would be eligible for this 12 weeks of paid time off. Interestingly enough, it also applies not only to school, because I know what most of you are thinking, well, most schools are closed this week or will be by next week, so I don't have to worry about it. But it also applies to programs like summer camps and other daycare facilities that a parent would normally use during the summertime to provide childcare for their children. So another just area of the law that you've really got to be mindful of when you're navigating through this. If an individual is being quarantined, has COVID symptoms, there's also a paid leave provision that applies where the employee is eligible for up to 80 hours of paid sick leave at their full rate of pay. So this law was designed to keep sick people home. And the purposes behind it is saying, CDC is saying if you've got these certain symptoms that we're hopefully going to be screening for, when employees answer yes to any of these questions that they've been screened for, this CARES Act now comes into play and says, all right, if you've got these symptoms, you stay home and the employer will take care of you and will make sure that you're paid. I'm going to wrap it up, so I want to be mindful of my time here and give my colleague Liz a chance to rail us into the end here and talk about some other interesting issues.
Thank you, Katherine. Before we kick it off to Liz, I'd just like to mention to everybody that you can use the Q&A and the chat box for any questions that we can take once Liz is done. But last and certainly not least, we have Liz Ryan. Liz is a production manager and an elected member of the DGA's National Board. Liz, we take it away. Liz, you're muted. Okay, thank you.
Sorry about that. Okay, so you heard Duncan and Anthony talk a little bit about what they called the union document, which the official name of it is the Safe Way Forward. And this did come out on Friday, and that's what I'm going to be talking about, because as a production manager, I am the boots on the ground that's going to have to put whatever policies we agree on into effect, and I will be the first line person that has to deal with any issues that arise from our crew or cast. So basically, the Safe Way Forward document, as they mentioned, was jointly created by the DGA, SAG-AFTRA, IATSE, and the Teamsters. And again, as Duncan mentioned, the most important protocol recommended in the report is regular testing, and also daily PPE to be supplied by the employer. It advocates that these 3 zones be created with varying degrees of isolation and safety. So in each zone, all crew will wear masks or face shields and practice safe distancing. No one will be allowed access to Zone A or B for the first time unless they've been tested and cleared within the last 24 hours. So this will fall on production to basically figure out what is the best form of testing, and it's the general consensus that temperatures would not be sufficient. So that is something that we will have to work out at the time we do start production. What is the most efficient and most accurate test at that time, and we want to make sure that everybody, at least 24 hours in advance, has been cleared before starting work. Zone A will provide extremely limited access. This is the set with only actors, the director, the first assistant director, the script supervisor, and the camera operator allowed access. And as crew working here will have exposure to unprotected individuals, namely the actors, the report advocates that all those in Zone A be tested a minimum of 3 times a week, if not more. And because turnaround time for testing can currently range from hours to days, how often tests are administered will depend on the evolving best form of testing and the time that it requires. Zone B is everywhere the production has a footprint that is not Zone A. Here, the use of PPE and stringent physical distancing will be enforced. And those who are cleared to work in Zone A, such as actors, when moving through Zone B, will be given a safe zone by all the crew in PPE, wearing PPE. So meaning, sort of like royalty, everyone will need to part so the actors can safely go through. And all those working in Zone B will be tested at least once a week, not 3 times a week like Zone A. And preferably, this testing would be done on a Monday, ostensibly to catch any possible exposure over the weekend. And Zone C is the outside world. Back to Zone B. In Zone B, crew will be responsible for disinfecting their own equipment. And if equipment is jointly used, it will be disinfected before and after each use, such as in construction. Catering and craft service will require all food to be boxed and eaten with appropriate physical distance. Cast and crew will be encouraged to bring their own food. And when possible, lunch times will be staggered to prevent crowding. Catering and craft service personnel will be required to wear gloves and masks at all times. Coffee machines and craft service trucks will be off limits. Coffee and snacks will be made pre-packaged and handed to crew by gloved and masked craft service personnel. The report advocates that hand washing and disinfection stations be placed throughout the set. Ample hand sanitizer should be made available on set and at the production offices. In the production office, physical distancing will require that all desks be at least 6 feet apart. Bullpen-style work areas should be avoided, and it recommends individual or departmental offices for their exclusive use. The report suggests that an effort should be made to work paperlessly. Machines frequently used, such as photocopiers, should be disinfected before and after each use. Kitchens will require gloves and no more than one crew member at a time. Bathrooms should be disinfected every 4 hours during the day or more if they are in frequent use. At the end of each day, when leaving a location, a professional hygiene crew will sanitize all the production spaces and all transport vehicles used, including the cast vehicles and makeup, hair, and wardrobe spaces. To maintain compliance with these safety protocols and to coordinate them, the report advocates, as Duncan mentioned, the creation of a new position, the Health Safety Supervisor. This person will be the Health Safety Supervisor will be the final authority on COVID-19 matters and effectuate HIPAA compliance as well. They would have the authority to pause the production in the event that an occurrence threatens the health of the cast or crew. The Health Safety Supervisor will oversee the testing process and work closely with the producers, the UPM, the first AD, and the department heads. The report advocates that working with the Health Safety Supervisor, a Health Safety Manager be hired to coordinate all COVID-related costs and sourcing of materials. And to that effect, if we do have fresh PPE every day, any studio that's considering starting up production should be stockpiling this now so as to be able to cover all of their shows. So this Health Safety Manager would coordinate all of these costs and the sourcing of materials. Supported by this Health Safety Manager and the staff, the Health Safety Supervisor will monitor the cast, crew, catering, and craft service for compliance with the zone protocols. They will ensure proper disinfection of surfaces, property, equipment, and tools, and they will coordinate placement of the hand washing, sanitizing, and disinfection stations and/or any medical posts. Each day, they will give instructions in the daily safety meetings, which are usually the first assistant director holds a daily safety meeting for the crew. And so now the Health Safety Supervisor will also give daily instructions on COVID safety. They will distribute the daily PPE and dispose of hazardous materials such as used PPE. They will purchase and maintain sufficient hand sanitizer throughout the set, and they will oversee the cleaning of bathrooms and overnight sanitation. And that's another big issue that is going to be coming up and is already coming up with production managers on shows. In other states, companies have sprung up whose their main reason for existing is to do truly sanitary cleaning of sets. LA is sadly short of these organizations right now, and this may be a problem when we start up production, because the normal people who would be doing cleaning are not going to do it to the standards that the crew and the cast will need. So this new department that will oversee COVID safety would also be overseeing the sanitary cleaning at the end of each day. In addition, a security unit will be responsible for keeping outsiders from entering Zone A without testing clearance and vendors from entering the premises. A couple of other important recommendations of the report include compensation for those who test positive until they can return to work. Every member of the production team will sign an attestation that they have participated in protocol training and committed to the principles and practices described. No visitors at all to the set or to production offices. A reception delivery area will be created outside of the base camp or production office. In other words, away from the set and away from the office. This becomes a disinfecting area. For example, any equipment dropped off would be sanitized here before being brought to set. Locked scripts should be available at the earliest possible stage of production to allow time for planning the enhanced procedures. Upon arrival each day, cast and crew will report to a medical checkpoint to receive their PPE before entering the set. While the initial test must be done at least 24 hours before beginning work, all subsequent testing will be done at the end of the workday. This would allow for a modicum of staggering and again avoiding crowds. Each production shall have its own specific COVID-19 safety plan to be coordinated with this and other safety guidelines. The plan must be provided in writing to every crew member upon their employment and to all suppliers and executives. And I know currently, in order for the DGA or SAG-AFTRA to approve a new project, they now need to approve the COVID plan as well. So I look forward to working with all of you in the future, and a number of these details we'll continue to be working out as we experience our boots on the ground.
Thank you, Liz. Thank you everybody for tuning in, and a very special thank you to all of our panelists for speaking on this topic. I would love to do some Q&A right now. We have questions lined up in the chat, so I will start with that and move over to the Q&A as we navigate the questions.
Celine, I'm
Yes.
sorry. Can I just add one other point that I just wanted
Yes.
to make sure didn't get missed? Because
Please.
I know Katherine made some detailed references to the LA County Health Order, Appendix J. And I just wanted to note that not only is screening required, but actually testing is required. If you look at the bottom of page 2 of that document, testing is actually required with the exception of very short duration projects where it's impossible to do that. So I just would encourage anybody who's looking at those documents, certainly in LA County, that's mandatory, and it's laid out in Appendix J. So I just want anybody to miss that point in addition to screening. Thanks.
Thank you, Duncan.
And I'm just going to add, we see a lot of questions in the chat about what this Appendix J is. As a reminder, it is the last attachment to the materials that you received today, and it's also part of the LA County Safer at Home Ordinance. It's one of the appendix to that order that can be found on the County of Public Health website.
Thank you, Katherine. All right, so I'm gonna go ahead and jump into some questions. I'm gonna be going through the Zoom chat and the Q&A. The first is, what if a refusal to return to work is unreasonable? Is there any remedy in dealing with an employee who is refusing to return in that situation?
Well, I could jump in on that one, and maybe others want to as well. I guess what I would say is the first question in my mind would be, is this someone who was under contract to this production from prior to the pandemic, or is this somebody who's been newly contracted to work on the production? And the reason why I raise that is obviously prior to the pandemic, if we're talking about someone who's in an ongoing role on a series, for example, that's continuing, I think the expectations for that person may be different. There obviously may be a fundamental change of circumstances as it relates to that person's employment. If, for example, they have a condition that makes them feel it's unsafe for them to return to work, et cetera. I think there'll probably be a slightly different analysis if we're talking about somebody who's newly contracted for, and if there's been proper disclosure of all of the precautions that will be taken in the course of preparing for production, that person enters into an employment contract, and then for whatever reason, without a change in circumstances are different, there may be more possibility of consequences in that case. But I think the bottom line should be, at least if you're talking about performers, I don't think producers can expect to get the kind of performance they want out of performers who are frightened to come to work. If a performer is in fear of their life for whatever reason on set, it's going to be very hard for them to deliver the performance that you want. So really, this is less about, I know this is a law panel and we're mostly lawyers, but I think in this case, this is more about good communication between production and the cast and crew, and less about the question of, what kind of penalties can you exact upon someone who is in genuine fear for returning due to safety issues. And hopefully production can find ways to assure people that it's safe. And I think the first thing to do is comply with all of these protocols that we put in place. And at least from the production we're seeing so far, in most cases, there is a great willingness to comply with the protocols laid out in the white paper, and also the protocols that we've just announced jointly, the unions have announced. So I believe we can work through this.
I'd like to add, if you're in a different type of employment setting where it's not contract-based or not talent, it's simply maybe, a different type of employee, not under a CBA, You have to be able to show that you're taking these safety protocols, as Duncan mentioned. And if a person doesn't have an underlying condition, isn't living with someone with an underlying condition, just has a healthy fear of COVID-19, I think you could move on to the next person if this person is refusing to come back to work and you're able to establish you've done everything you need to do to make it as safe as possible. And you need a body in that role, and there's no other way to accommodate that person. I think you would be able to, but it's a very fact-specific question, and you really have to look at the unique circumstances surrounding the particular job in question and the employee's concerns.
Thank you. I see a lot of questions on workers' comp and how COVID-19 is being treated differently, and whether it's necessary to evaluate what the sickness and it being taken place at work, if there's a difference if the employer provides a health plan. Would anyone like to tackle that question?
Sure. This is Tony. I'd be happy to answer that. Ordinarily, if an employee suffers an injury or contracts an illness in the course of employment, it is covered by workers' comp, and unless there are, under very limited exceptions, the exclusive remedy for the employee is to file a workers' comp claim, and it's a no-fault system that provides medical treatment, temporary income, replacement income, et cetera. The governor of California issued an executive order that says that anyone who is required to leave their home to work in the state of California until the state of emergency is lifted is going to be, and contracts COVID, is going to be presumed to have a work-related injury. I mean, essentially, the government is saying we don't want people to be litigating over this issue, and if somebody has to go to work and leave their house and they get COVID, then we're going to have to assume it's work-related, and there's a system in place to cover the employee's injury. Now, the employer or their insurer, if they could actually establish something to rebut that presumption, that may be possible. But truthfully speaking, how you would ever be able to establish where someone was has contracted AIDS, COVID-19, is going to be very, very, very difficult. So, so it is really just a policy decision that the state has made that workers' comp will be covering COVID infections for people who work outside the home.
Thanks, Tony. We're also seeing a lot of questions on the frequency of testing and the administering of that. Duncan, I'm wondering if you want to jump in on answering that.
Well, sure. I think, Liz talked about some of the details of that, which I greatly appreciate. Thank you for that, Liz. And it's actually been a real pleasure to work in cooperation with the DGA. I think it's worth noting that actually the DGA took the first pass on that draft, and their committee has been just doing extraordinary work. It's very impressive. As far as the testing goes, I know we're mostly lawyers and not scientists, but I would encourage everybody to look at part 2 of the Safe Way Forward document, because it really lays out the scientific basis for what Liz was explaining about what the frequency of testing should be. And what that document essentially shows is there's a dramatic reduction in the probability of an infection occurring on set with testing. There's a huge impact even from weekly testing, but there's a significant additional benefit from 3 times a week testing. The benefit is marginally less as you go to daily testing, which is why the unions did not settle on daily testing as our recommendation. However, for certain intimate scenes or situations where performers may have to do a lot of exertion, like a fight scene where performers might be in very close proximity with a lot of exertion. I'm sure everyone's read the material that shows that really like how much exertion you're engaging in and how much vocalizing you're doing can have a huge difference in potential for transmission. So there is a reference in the document to potentially using daily testing to help protect performers and those working around them in that situation. So it is a little bit situational, but what I would say is I know there's also been a lot of questions about, is it practical? Can it be done? Is it too expensive? And what I would just say is we at SAG-AFTRA, I know the DGA has done this too, we've been directly in contact with every major commercial provider of COVID testing, and also a bunch of newer boutique providers, let's say, that are focused on businesses and employers. And our epidemiologists, we have at least 4 of them involved from the different unions that are involved in this, have all looked at this as well. And the belief is, number one, that, that there is a sufficient capacity for testing given the level of production that's happening now. Number 2, that the testing capacity is ramping up faster than production will ramp up. So we expect there to continue to be enough capacity. And number 3 is, I'll just say anecdotally, we have, for example, a low budget feature film that is currently shooting here in Southern California that was able to get testing on the timeframes that we're talking about at a cost that was manageable for their budget. We have commercials that are doing the same thing. I can think of one right now that's shooting in Utah that has testing. They're actually doing daily testing, I believe, if I remember correctly, in that commercial. So the fact of the matter is that that testing is available. Yes, it's maybe a little bit of a hassle to arrange it. It's an extra step, it's extra work, but I think we have to remember this is not business as usual. The goal here isn't just to like paper over the problem and just have everyone go back to doing everything the way they did it before. This is really figuring out how we can do things in a way that keeps people safe and prevents these productions from having to shut down in the middle because of an outbreak of COVID. So I think producers and lawyers for producers should remember that this is not just to protect the employees. It is to protect the employees, but it's also to protect your production. It's really to protect everyone. And so that's why I think there's been so much ability to work together as Anthony and Katherine and Liz all mentioned.
Thank you, Duncan. I want to mention to everybody that we are out of time. So if, but some people are still asking questions and we're maybe able to take one more, but if anybody does have to jump off, I want to give one more quick shout out to our wonderful panelists for being here. A lot of them have time commitments at 1:30. So I want to make sure that they know that we all really appreciate their industry knowledge here. So thank you guys. And if you have to jump off, please feel free to jump off. We can take one more question. I see a couple of questions surrounding actors or crew members or people getting sick or being tested positive while on set and then being required to have a 14-day quarantine. What does that look like in terms of whether that person is going to be continuing to work for the employer and get paid? So I think, Duncan, if you'd like to answer that, and maybe Tony, if you want to jump in as well.
I would just say the first test, it doesn't trigger a 14-day quarantine. If somebody comes back with a positive COVID result, the very first thing that's going to happen is they're going to be, temporarily segregated, kept home or whatever, and then a confirmatory test is going to need to be done. So, really, there is the possibility of false positives, even with the best quality tests that are out there, and so that is something that has been discussed with everyone, which is that there is a protocol for confirmatory testing. If, of course, someone does, the confirmatory test is positive, then they will need to, discontinue participation in the production until such time as they test negative again for the virus, which might be 14 days or might be less or might be more, depending on the person. The understanding as to the white paper and to the union document is that those people will be paid for the time they were supposed to be on the set, basically until the end of production or until the end of their expected work on the production, whichever is shorter. And I think that's really important as a public health matter because you don't want people to be trying to avoid testing or trying to sneak around it because they're afraid of the economic consequences of coming down positive with a test. So far I have not detected strong resistance to that principle in the discussions we've been having, and it is embedded in the white paper. So I think it'll be interesting to see how governments adopt that and how non-union employers deal with that. But I believe in the union part of the industry, that is what will happen.
Thank you, Duncan. So we are out of time. I know we have a series of questions out there, but a lot of this information can be found in the program materials. So we encourage everybody to check those out. And let me see if we can try to sneak one more. Any questions relating to the guidelines, the Safeway Joint Report or the white paper or anything issued by Governor Newsom or the LA County Health Order, they're going to be mentioned they're going to be referenced in our program materials. So please take a look at that. And if we can't find them, maybe Fatima, we can do a resend of those to all the attendees. But other than that, I think that's what we have for everybody today. Thank you all so much for joining in, and we look forward to seeing you at our next event. Thank you.
Thank you.